Good afternoon, members of the Senate Science and Technology Committee. For years, consumer rights, racial justice, and civil rights advocates, including the ACLU of Georgia, have called for meaningful privacy regulations that empower people to live their lives free from intrusive corporate surveillance and to discrimination that could be empowered by technology. We are so excited that Senator Albers has brought forward language on this bill today. I think Senator Albers was the first person I spoke to when I started this job, and it was specifically on this issue when we were talking about language. So the fact that this is something that's being taken seriously, we just want to thank Chairman Albers as well as this committee for considering the bill. That said, the language as it exists in SB 473, being based on the Tennessee law, in our view, does not meet the requirements to protect people's privacy and would legitimize a status quo that protects big tech companies' profits and not the people's privacy. The ACLU of Georgia urges this committee consider putting the privacy of Georgians first when considering language that would be more effective. I'll get to some of those in a little bit. I don't know if any of you have tried to rent a house, rent an apartment, or buy a car, or do other types of things like that where there's scams that have been taking place in the commercial setting, but you're often going to be required to provide your iris pattern, your facial geometry, and your fingerprints. I know when I rented an apartment a year and a half ago, I had to provide all of those. And when I was buying a car, I had to provide just my facial geometry to the car dealership. Right now in Georgia, I have no control over how that data is used, how it's retained, and how it will be disseminated. Corporations have built a surveillance economy that seeks to collect as much information about about a person in order to turn a profit. Just as those examples I just gave, they can harvest data from what we do at work, what we do at home, what we buy, where we go, what doctors we see, and all our context with the criminal legal system. At the federal level, these companies face almost no real restrictions on the amount of data, personal information they can amass, or the ways they can use or exploit this data. And in the absence of meaningful state protections, companies have compiled massive dossiers on each one of us containing staggering amounts of information. This information can identify us from our interactions with the world, that's both online and off, within our homes and outside of them, creating the potential for private surveillance on a massive scale. And when we're talking about the issues of biometrics, especially when it comes to facial geometry, our iris patterns, and these kinds of information, we don't know the scope of how this information can be used in the future. Technology is changing, especially with the interplay with artificial intelligence. So we see right now, and is why we do thank Chairman Albert for bringing this bill, that we're kind of at a threshold moment in terms of our ability to control this data now. Some information that can be sold to data brokers or used to power surveillance-based advertising. We have seen in other states discriminatory impacts when companies exclude people from their businesses or advertisements for products they would buy based on their race, gender, or nationality. In order to stop these harms, consumer privacy legislation must, at a minimum, contain strong restrictions on the amount of personal information that can be collected and the ways it can be used, requiring opt-in consent before companies can collect this data. And that's one of the biggest things from this bill, where when it talks about the data center, the majority of which would be opt-out, and so giving them that opportunity instead of requiring that affirmative consent. Providing users with the tools to access and control their personal information. There are some of those protections in here, but when it comes to de-aggravated or depersonalized information, that control no longer exists. And creating strong civil rights protections. The only civil rights protections I saw in this bill, with the exception of some base language about race and gender, which is a good starting point, but it's not concrete civil rights protections. The only reference to the Constitution was the right of the companies and their First Amendment rights, which should be protected, obviously, but we think that there should be stronger controls. As well as enabling people to sue privacy-violating companies for attaining their personal information for their monetary relief and abusing these practices. We don't think SB 473 goes far on any of these issues. And that's why we're asking this committee to put Georgians' privacy first. I've sent a memorandum to every member of this committee with our blue ribbon model language, which we think is the representation of all the bills that I know that Senator Albers has looked at. And when looking at it from a privacy standpoint and putting consumers' privacy rights first, it takes out all the strongest elements and puts that in one bill. Again, I'll go back to say that I think we're in a bellwether moment about what we can do right now. So when we're thinking of language, I think that putting it on the onus on companies to build on a platform that protects privacy is what the bill that should come out of this committee would be. And we've suggested 5 states where language has either been passed or is being promoted that does put privacy first. None of these bills goes as far as we want them to, but they would serve as, we think, better alternatives with the language. The Texas bill in particular doesn't go anywhere near as far as we would want it to, but has been in effect for 12 years now with no changes from what I've provided in the language that you have in front of you. And I think this is a compromise we can all live with. If businesses can do business in Texas, I believe that they can live with it here, and it's putting the data rights of consumers first. It doesn't contain a private cause of action, which will always be a sticking wicket, but at least if we get these protections, that can be something that we can look to down the road if it's necessary, just as tech companies can look for exemptions as they're necessary. But we think that the bill that comes out of this committee should, as a baseline, put these protections first. With that, Mr. Chairman, I'll yield for any questions, and I'm happy to explain any items in my memo as well.
Appreciate your presentation. I've got a few. Are there any questions for members of the committee? Yeah, no questions. Chair recognizes the vice chair.
Could you go back over the list of states you said that had?
That's right. So in your materials that I provided, and I'm happy to resend the memo. I should have it in front of me.
And I would tell you, just not to shoot too low.
Yeah.
You send email to members during a legislative day.
I understand 100%.
They're not printing these out and reading these things.
Of course. And so I would love to, as this body's considering further details, I'd be happy to print out that bill language and get it to people. But the just a second. The language, if I remember correctly, it was Illinois and Texas are the ones who have passed the laws. And I think it's Washington, Massachusetts, and one other state that provided language for that has, and the critical things in those bills are the opt-in consent, which is basically if they want to be using your information, just like when I tried to rent an apartment, they have to say, we're collecting this data and what we're using it for. Other things that are required is the ability, requiring businesses to destroy that data after a certain period of time. I think the Texas bill, as well as our model bill, uses a year after the last contact with that person or for the purposes of the collection. And they also have it where there's data minimization. The data minimization in this bill is for the purposes that are disclosed, and that could be buried in a privacy statements, and not necessarily the purposes why that consumer engaged that company. And so we think that that would be a necessary thing. And that's something that those bills that we provided language for actually include.
Okay, thank you.
Thank you. I had a few questions. I think I lost some of them in the discussion. You talked about the opt-out versus the opt-in. And you talked about the multiple states, sort of this, and that's something that Chairman Albers alluded to. That
100%.
We're already seeing this movement across the marketplace. It's easier, I guess, for businesses that operate nationally and internationally to have one standard, maybe at least across North America. Maybe they have a different one in Europe under their GDPR rules, but maybe one for here that's more common. So it's some states adopting a standard starts to make it happen other places. What specific movement have we seen as a result of specific policies that you alluded to? Are we getting opt-in opportunities in Georgia because some states have required opt-in?
I would not. I have not seen any data suggest that that's what businesses are doing. It was more of the understanding I had when I was going to, go back to the apartment thing, there was no opt-in consent. It was, if you want to apply for an apartment here, this is what's going to be provided. When I would push back against that, because I don't want my iris patterns or facial geometry to be recorded by that was told, you can find somewhere else to live. So I don't think that that is something that's being reflected by these small smaller people who are collecting data right now. And I think that's another point that's important to mention here, that we actually look at who's covered by this article. We're talking about like the small property management company that I did that through when I was running an apartment wouldn't be covered on this bill because they don't collect data of over 25,000 people with a certain number of business context for selling data. So I think that that's another important thing about this bill is the scope of who it actually covers is somewhat limited. But I will say, in terms of movement, that Georgians have actually had increased protections regarding their consumer data because stronger bills were passed in other states. That's absolutely true. There was a very large lawsuit that occurred in Illinois based on a Consumer Protection Act that actually protected Georgians from having their data collected for 5 years by some known bad actors. And that's something that, so Georgians were actually able to benefit from the actions of their states. And the reason that we would like to see stronger protections here is because I don't want Georgians to have to rely on the protections of other states. I would love to see language in this state that protects Georgia's rights first.
As you mentioned biometrics, I had a credit card breach that happened. Someone got my credit card number and they were running things up. My wife was texting me, "Did you buy something here?" I was like, "No, I didn't buy anything there." So we had to clear our credit card. Same thing can happen to passwords and such. Question about the biometrics. I can blank my credit card in a couple of days. They can FedEx me a new one and I can be up and running it again and I can travel and the things you need to do with a credit card because it's replaceable, as is a password. My concern around biometrics is that I can't wipe clean my iris scan or my fingerprints. It's indelibly mine. And if someone owns that, they own my biometric forever.
And Chairman Susser, what I would like you to consider as well is, because that's very well stated and it's a huge issue, but what also I would offer to consider is we don't understand what information could be gleaned from information. Is there some genetic material that makes our iris pattern work a certain way, or facial geometry work a specific way that can be used against or discriminated against consumers that we just don't know the scope of?
That could be. And so I'm not dismissing that.
Sure.
Maybe I'm dismissive a little bit. What I'm, I guess, more concerned about is on that front.
Right.
I can never undo I can't change my finger. I can't go in and have my nose can be improved more easily than my fingerprints can be, right?
Yeah.
So when we talk about biometrics, we talk about, essentially saying a violation shall not serve as a basis of any right of action, class action or individually. So if a small entity, like your apartment complex, lost your biometric, you have no action. The law is kind of a Wild West right now relative to that. You may or may not have an action.
Right.
Under this, if a big actor lost them at scale, there's nothing you can do because there's no private right of action and there's no ability to do a class action lawsuit if they lost biometrics at scale, as I see under this. Is that your read of this? I know I talked to Chairman Albers about the civil side of this, creating that balance.
And so one thing I would especially caution, and that language you're referring to is lines on 641 and 642 of the bill,
Yes,
where it limits the cause of action or a basis for under this article or any other law. And so with that, especially with that caveat of any other law and other consumer protection that might be available at the state level in terms of like, fair business practices and that I might have a claim for, or in tort, I might have a claim for, that this could preempt that with regard to large companies.
My biggest concern, as I shared with the chairman for the committee, was this 641, 642. This creates an absolute, almost indemnity. You're unsuable as an individual for the only one that could ever bring a suit against you is the attorney general, no matter what happens civilly. That's something we're trying to, I know the chair was, we talked about that piece and what that meant. So I just wanted to, your remark about the biometrics catalyzed my thinking on that. So. Yes, sir, Mr. Chairman.
Mr. Chairman, if I could as well, I always appreciate Ben's insight and wisdom. I think we always want more, right? And if I've learned nothing in my service down here, and you and I have been here for a minute now, is sometimes you have to take incremental steps forward.
Yeah.
And in lieu of having nothing, I think we can make some necessary tweaks here, but in lieu of having nothing, we're advancing the ball forward. And I think if we can do that in a way that everybody gets a little what they want and other people are a little bit disappointed through that process, that's probably a pretty good bill I've learned while we're down here.
Yeah.
And what I don't want to do is it be an us and them. between our business community and others, right? We want to come up with something we can all say, you know what, this makes sense. We're moving the ball forward. Now, here's what I can promise you. In the years coming, this will change because technology is rapidly evolving in real time. So will we be back here in 2 years from now, probably in, the same room doing this again because something has changed? The answer is absolutely. And a lot of that will be driven by artificial intelligence. But for now, I think the premise of the bill is very strong, maybe with some great wisdom and tweaks that you and Ben have brought forward. But I would urge us to think about something as 100% more than nothing.
Well, I don't know what Ben's got. I spoke to him for 5 minutes in the hallway today, so I don't know if he has any suggestions. I'll leave that to you. Anything else you'd like before you wrap?
Just, thank you, Mr. Chairman. The only thing that I would, it's another caution, is this safe harbor provision. I believe that, and that's on lines 646 through 662. I believe Tennessee was the first state to adopt this safe harbor language. And I do think that I have no concern about NIST. I think that they're a great company in providing practices for companies and how they engage technology. As a person who has a difficult time just turning on a computer, I defer to their wisdom a lot when I talk about data and privacy. I'm concerned that this bill, with that safe harbor provision, as good as NIST is a floor, is actually creating that NIST standard as a ceiling, and especially with this preempting other local action and the private cause of action. That's just another thing that I would flag for the wisdom of the committee. In terms of I would just go back to my recommendation that I agree 100% with Senator Albers regarding that anything is better than nothing, and Georgia's rights should be protected. I would again just go back to the Texas bill. It's 2 pages long, and in terms of doing something, it does set a floor that's again used in Texas for 12 years that puts consumer rights first. Instead of, again, as much as I know we want to maintain Georgia as the #1 place to do business in this space, I think that those consumer protections should be what the highlight are. That's all I have.
Okay. Appreciate your time.
Thank you very much.